Good morning or afternoon. Thanks for joining us today. You've tuned in for the webinar Working with Universities. I'm your host, Jennifer Januska, Director of Intellectual Property for Protein Industries Canada. Protein Industries Canada is headquartered in Regina, Saskatchewan. And I want to acknowledge that this is on Treaty 4 territory, the original lands of the Cree, Ojibwe, Saulteaux, Dakota, Nakota, and Lakota, and the homeland of the Métis Nation. We respect and affirm the inherent and treaty rights of all Indigenous peoples across this land. We have and will continue to honor the commitments to self-determination and sovereignty we have made to Indigenous nations and peoples. Now, as many of you know, the Global Innovation Clusters were recently renewed for a second 5-year tranche of funding. And in fact, we've just closed a first call for expressions of interest for Fund 2 projects. One of the requirements for PIC Fund 2 eligibility is a consortium of at least 3 entities. These can be companies, organizations, or academic institutions. When we talk about collaborative innovation, we know that universities play a key role and are a major driver of discovery and commercializable research in this country. We have got a great panel of speakers lined up for you today, and I'm going to let them fill in a bit more about their backgrounds and biographies themselves, but I'll just give a very brief introduction. Dan Polonenko and Jeffrey Coles are partners in the Calgary office of the law firm Gowling WLG. Dan is a patent agent and Jeff is a lawyer. Both bring extensive experience working with complex IP strategies and helping companies to achieve their business goals through IP. Both also have considerable experience with university IP, having worked for universities and with universities with companies seeking access to university IP. Dr. Ian Stavness is the Director of Plant Phenotyping and Imaging Research Center, the Enhancement Chair of Computational Agriculture at the Global Institute for Food Security, GIFS, and an Associate Professor in Computer Science at the University of Saskatchewan. His research team focuses on the application of machine learning and computer simulation in crop breeding, agronomy, food production, and food processing. Ian's team collaborated on the Developing Artificial Intelligence Spraying Technology project in Fund 1 of PIC. Before I turn it over to our first speaker, Dan, I'll mention that all attendees are muted. You can use the Q&A function in Zoom to ask questions. Feel free to pop them into the discussion as we go. And we may address them during the presentation, or we will plan to take them up at the end. And with that, I will turn it over to Dan.
Thank you, Jennifer. And I'm just adjusting my screens here so I can see what I'm talking about. There we are. So I'm going to start out by using a few slides that are an overview of PIC's funding program. And these slides came from a presentation they've been giving during their 5-year strategy planning sessions that have started in March. So Protein Industries Canada has 4 technology pillars that they're funding projects under. 50% of them are for ingredients, projects associated with developing and scaling ingredients. 15% is based on genetics and breeding, 10% on crop technologies, crop production technologies, and 25% on products. 50% of the funding is going towards technology scaling, and 20% for proof of concept, and 30% for commercially ready products. And so in terms of IP, it is likely the top two, where there will be new IP that comes out of the PIC projects. PIC projects require at least 3 PIC members and at least 1 small medium enterprise, and all of the consortium members, 2 of them need to provide funding, and non-Canadian entities can participate. So here are the must-haves for a project to get funded. You have to have a good supply chain. You have to have technology that works, or be developing technology that can be scaled up. You have to have intellectual property, and you have to have a business plan, market strategy, and the end product has to be delivered. So PIC has an IP rationale and government strategy required as part of the application process. And so this is something that we're going to be talking about. What does this involve? How do you get ready for that? What's included? And on the Protein Industries Canada website, you'll see that there's a members login, and PIC has a number of things that are available only for members to access. And one of them is the IP Hub. And it's basically an overview of all the projects they've funded. That is not a trade secret. And it's amazing how much stuff is in there. So you need to log on as a member, sign up as a member. That's a $500 annual fee, and it's well worth it for what's in there. And then as you're developing your project proposal, you should be meeting with Jennifer Janeska, who is PIC's Director of Data and IP. So we've known Jennifer for some time. We've worked together with her in the past before she joined PIC. And she's an IP lawyer and a registered patent agent in Canada and the United States. And she's provided IP services for about 20 years. So she's a great resource for you to talk to. So these are the IP protection options that you should be aware of. There's trade secrets, there's patents, which include industrial designs, there's plant breeders' rights, there's copyrights, trademarks, and domain names and your websites. So you'll need to be familiar with different categories of IP. First of all, there's background IP, and that is the IP that each of the PIC partners is going to bring to the project. So these are your trade secrets, and there's a list of what else you might bring. And then foreground IP, and this is what we're going to be talking about primarily today, and that is the IP that arises from a PIC project. This is the new IP that PIC is looking for to be developed and to be commercialized. And then depending on who the partners are, they may be producing other IP that doesn't relate to the PIC project. And so that's shielded away, fenced away from the PIC consortium members. So here are some good management practices to get ready for putting together and submitting your PIC proposal. You need to prepare an inventory of your current IP. If you're working with the university, you should identify who the professor is that you'll be working with. And you also need to understand from the professor who will be on their team. The professor is not going to be the one doing the work. They'll be the project manager internally. They may have a postdoctoral fellow or they may have graduate students, or they may have undergraduate students, and they will likely have technicians. And the reason this is important because the professor's university will have an IP policy. So you should download that. They're publicly available on the university's website, because different universities deal with arising IP from the different categories of people that I just listed. Something else you need to understand is who should you be contacting at the university to negotiate the agreement with. And this is important because universities typically have an industry liaison office or a tech transfer office, and their primary function is to understand and protect the IP that is being generated within the universities by professors, protect it with patents, and then to license it out. But PIC projects are different. They are led by companies and by business, and they're approaching the university for an applied research contract. So in that context, the university will be a subcontractor or a service provider to the PIC project. And something else that needs to be included in the collaboration agreement, and Jeff will talk a little bit more about this, but you need to have a section on how the ownership of foreground IP that may arise from the PIC project will be allocated. So for each of the 3 collaborating PIC members, there we are, you need to put a list of trade secrets together, and only those trade secrets that will be used in the PIC project. This is what you're going to be sharing with your partners. A list of relevant patent applications and issued patents, if you have any. A list of registered trademarks that you'll be using within the project. And the scope of what each of the PIC members will be delivering to project success. And also a list of the deliverables and a timetable for those deliverables that you're expecting from the university collaborator. So I'm finding that my computer requires a double click instead of a single click to advance the slides, so my apologies for that. So another good management practice is to make sure you document everything. This is very important. So you should have directories and subdirectories of all the email correspondence. You will have formal meetings between the project collaborators, so you should be preparing and circulating formal meeting notes. And then all of the raw processed and compiled and summarized data, you should have that readily available and accessible. And all of the interim and final reports associated with the projects should be documented. And all of these things are trade secrets that belong to the PIC members who created and who are managing the project. That's very important. So the primary goals of PIC-funded projects are not to create patentable inventions. Rather, it's to create valuable IP, which could consist only of trade secrets, but the success of the project depends on those trade secrets being developed. Usually, when you realize you have a patent, that's usually some time after the project has ended. It could be a couple months, it might be a year or two. And that's why the documentation is so important. But what do you do then? And the goal of patenting is not to disclose and protect the technology, but rather it's to protect the revenue streams that will arise from the business opportunities that are created by the technology in the different industry sectors and the countries where you want to commercialize. And these are the product streams. And Jeff, yours to take over.
Thanks, Dan. So I'm going to jump in here. I'm going to, Dan and I both are with Gowling WLG, international law firm, over 1,500 professionals worldwide. So we work in this space all the time. I mean, Dan and I are in the Calgary office of our firm, where we work as teams to help our clients capture these revenue streams of intellectual property that they are creating. And I'm a lawyer, so Dan often is a little more willing to take risks as an entrepreneur than I am. I'm gonna my part of the presentation here might be a little bit more rigid, and we're going to cover some legal concepts here on ownership and how you should work with other parties in these collaborative type settings. But it's important from the outset to recognize, as Dan said, that the goal of any intellectual property strategy is not to protect the technology per se, but to protect revenue streams and capture commercial opportunities for companies. So, within the PIC project and within the collaboration with universities, this is what we should be thinking of: is how is the project going to evolve? What are the revenue streams that might come out of the research that is being done? And as I'm going to go over in my next few slides here, you need to be thinking early on about who's going to own that IP and who needs to own it for what they want to do in the future. So Patent claiming strategy. You need to be thinking about what your revenue streams are for your business so that the patents can be appropriately drafted by professionals like myself and Dan to capture that revenue stream and make sure that others can't easily design around your patented technology, or that you have also captured your commercial embodiments. There's various different types of claims that can be included in patents, and it's important to be aware that this is a non-exhaustive list that we've thrown up here. Really, there's prescribed limitations on what can be patented, algorithms, abstract theorem, things like that. Outside that, higher life forms cannot be patented in Canada. Outside that, really, there's a lot of opportunity for patenting, and we have a list here of some of the things that you should be thinking about. Your products, so your systems, the apparatus, the modules. How are they going to be sold? Are they going to be sold as one piece? Is there consumables? Should they be sold as kits of parts? All of that you need to think about when drafting claims for products. Methods. So then there's the production methods for making something. There's how something will be used. You can have claims directed to both of those. Is it going to be sold as a compound, or will it be a composition? You can have both those style claims in a patent application. And then Dan and I both practice more in the life science and mechanical space. We do have others in our group who have PhDs in electrical engineering and focus on the software related technologies. Whereas software per se is not patentable, there are various different avenues to patent inventions that relate to software. So, the general line of thinking that software is not patentable is it can be tricky in some countries, but there are some ways around it. Oh, sorry, I think I muted myself. Okay. Dan, if you want to go to the next slide. Perfect. Okay, so I'm going to cover some of the legal concepts of, and maybe if you want to click the button again, I think some of our slides ended up having animation to them somehow. Oh, okay. Anyway, that's fine. I thought this slide had another aspect to it, but anyway, there we go. There it is. Okay, so there's an important distinction in patenting between inventorship and ownership. Inventorship is a legal criteria. It's required that all proper inventors be named on a patent application or on any intellectual property for that matter. And generally an inventor is anyone that provides a substantive contribution to the inventive subject matter in the application. Now, early on when you're drafting the application, you may not know where the claims are ultimately going to land. You'll have claims in your original application. The application will undergo examination and the claims may be revised. Inventorship in respect of the initial original claims versus granted claims can change. And some countries do require you to amend your inventorship, such as the US. So inventorship can actually change as compared to an originally filed application versus a granted application. But the important point from a legal perspective is that all proper inventors should be named on a patent application, and there can be legal consequences for not doing so. Now, an inventor is someone who provides a substantive contribution. So what do I mean by that? Well, a mere pair of hands is not technically considered and not usually considered an inventor. So someone who you've hired to perform. I often think of someone, someone at the lab bench who's doing work upon instruction. They might not rise to the level of an inventor. So sometimes it's important to seek guidance from professionals to help you determining the proper inventorship on an application. Now, ownership is completely different. While initially every inventor on an application is also an owner of that technology, usually there are contractual agreements or presumptions that shift the ownership of the technology. So by default, the inventor is the owner, but contractual agreements that are put in place, or being hired to invent a particular type of technology, can shift that ownership to a company or other entity. And best practice is to have assignments executed that detail the complete chain of title, so that if your patented technology ever goes to litigation, or if there's ever a due diligence, you have all the proper documents in place. So joint ownership. So patents and other intellectual property can be jointly owned. There are some benefits to having jointly owned IP. However, there are pitfalls that you have to also be aware of. And oftentimes the benefits of joint ownership do not, if you want to go back to the last slide there, sorry, Dan. Often the benefits of joint ownership do not outweigh the pitfalls. So usually again, it all depends on the situation and circumstances, but often it's prudent to have a single owner to a patent. So some of the benefits to joint ownership are obviously, sharing of costs. That might be filing costs, it might be prosecution costs as the case progresses through examination. And obviously having joint ownership can also promote cooperation and sharing of ideas, because the interested parties are more interested in sharing ideas with everyone because they know they're going to be a joint owner of the technology. However, there are pitfalls, and this is where I think you really need to think about whether joint ownership is the right way to go. So in most countries, in situations of joint ownership, each owner of the patent is able to independently sell, license, or exploit their ownership rights without the consent of others. So you could have, if you have for example, a large entity and a small entity, perhaps that jointly owns a patent, perhaps that large entity is able to leverage their network better and sign deals and licensing opportunities more easily than the small entity. Thereby, they're able to reap the benefits of the patent, whereas a small entity might have challenges. There are some exceptions to this rule, particularly in Canada. In Quebec, you actually do need, it's where we're under the civil law, you actually do need the consent of the other owners for any kind of assignment or license of one owner to a third party. The rest of Canada, there's a general common law principle that one owner cannot dilute the ownership interest of the others. So while they could assign or license to a single entity, they couldn't assign or license to multiple entities without the consent of the other owners. So some of the other pitfalls, as you'll appreciate, with joint ownership, it can be impossible to grant an exclusive license without the cooperation of all of the owners. So if you think about that, often third parties interested in acquiring a license to patented technology, they will want an exclusive license to prevent others from also entering the market. If there's joint ownership, it can be difficult to guarantee that they will have that exclusive license, because there are other owners to the patent who could also license the technology to different third parties. In some countries, a jointly owned patent can only be enforced with the consent with all of the joint owners joining in the litigation. So that can be a downside. And then there might just be disagreement between joint ownership on how prosecution proceeds. During examination of patent applications, a strategy needs to be adopted on how claims will be amended, how arguments will be presented. And sometimes with joint owners on a patent, there may not be agreement on how prosecutions should proceed. And then obviously, for raising capital, often investors are looking to invest in a single entity, and having joint ownership on a patent can present challenges to raising equity for a single company. Next slide. So very quickly, some considerations for dealing with university or dealing with really any third party in a PIC project agreement. So as Dan highlighted earlier in the presentation, you need to know what your background IP is. You need to identify the relevant background IP that's going to be part of the PIC project. And you need to determine how that background IP will be used in the PIC project and how ownership will proceed throughout the PIC project, whether it be during the project or afterwards. Will it remain solely owned by a single contributing party, or will it be assigned or licensed to others? And it's important to think about this early and what the commercial opportunities for each of the PIC consortium members are, because if one company is bringing trade secrets into the relationship or even patented intellectual property, perhaps in the long run, all of the consortium members, depending on what their business models are, might need a license to that technology to be able to capitalize on the opportunity. So you need to think about these things early in the agreement and set up the agreements appropriately. And obviously, there should be confidentiality clauses, particularly in regards to any trade secrets that are being brought into the project. Next slide. So that was background IP. So what about foreground IP? This is the IP that's going to be generated during the PIC project. So here, we'll obviously in the setting of this this webinar and this presentation, we're focused on a university collaborator, but a lot of these high-level comments go to collaborating with any party, really. But when working with a university under a PIC project, typically the university is going to come on as a subcontractor or a provider of some research and development service. So you need to structure the agreements appropriately, and typically, outside working with universities where you may not have to consider the university's IP policy, typically in working with subcontractors, you would have provisions in that agreement to ensure that the intellectual property remains owned by the contract, by the company that's hiring the contractor. So it can be different in working with universities, and you need to be mindful of each university's IP policy, particularly in respect of contract research. Different universities across Canada do have different policies. There's not necessarily a right or wrong answer. It's more about being aware of what the university's policy is that you look to work with. And also, so working with PIC, Dan and I and Gowling, we've generated a document that provides the intellectual property policies of most of the universities across the country, from what we could find from publicly available information, and I believe we'll be making that available. Is Dan? That's my understanding. Anyway, this document will be made available. I want to stress that it was based on public information that we were able to find, and that it's not necessarily the case that a university's IP policy is set in stone. Sometimes it's about negotiation, and sometimes it's about who you're going to be interacting with within the university. Is it a grad student? Is it the professor? Is it an undergrad student? The important point is be mindful that universities do have different IP policies, and understand what you're getting into and what the policy is. And then it's very important and sometimes missed. You need to know who's going to be on the university collaboration team. And from a patenting perspective, this can have consequences too if you begin emailing someone who's not part of the collaboration project. I mean, that could arguably even be considered a public disclosure, which can be problematic for patenting. Okay, some of these next ones are quite a bit quicker. Make sure there's appropriate confidentiality clauses in the agreements that define the ownership of trade secrets. As Dan mentioned earlier, you need to be documenting things along the way, and there's going to be a lot of trade secrets and proprietary information that's generated during the relationship. The document should stipulate time periods for maintaining the secrecy, and if it's trade secret information, there should be consideration given to an indefinite time period, since that information might never be disclosed to a third party. If patent, you need to be considering early on whether there's a likelihood of patentable foreground arising in the project, and if so, who should own it. And this can often be a subject of contention in drafting these agreements, but it is important to spend the time and get it right at the outset. And as the project evolves, you need to rethink these things sometimes, but also you should document and have assignments put in place along the way. Next slide. Yes, that's it. So I want to thank you for your time today, and I also want to thank PIC for the opportunity to present here. If there are any questions, Dan and I are more than happy to answer them as related to our part of the presentation today.
Well, let me just jump in while Ian is setting up his slides. Thank you so much, Dan and Jeff. And there's a question which I guess I'll answer. The question is, will that document, in other words, the summary of the publicly available university inventions policies, IP policies, be made available to attendees? And the answer is yes. So I will. I'll make sure that that everyone gets a copy following this as a thank you for being with us today. All right, and we'll turn it over to Ian.
Great, thanks. Thanks very much, Jennifer, and thanks to PIC for inviting me to this nice panel today. I just want to start by saying that I really do think it's a great time to work with Canadian universities. I think that the sort of old stereotype of professors only wanting to publish research papers is, completely gone, and all of us and professors really are searching for impact. So we really want the work we're generating to be used and to contribute to the competitive advantage of Canada across different sectors. So I think it's a great time. I do really want to thank Dan and Jeff for their presentation. I do think this IP literacy and sort of general education, I think, is extremely critical, not just for PIC, but even within the universities. I think we currently do a poor job of this sort of education, and I think that I really want to thank you guys for providing that information today, and I'll definitely be prodding you for these sort of opportunities in the future, through universities. So as Jennifer mentioned, I was fortunate to be able to engage in a Protein Industries Canada project in the first phase of PIC. This was a project led by Precision AI, a company based out of Regina, and we joined that consortium through the Global Institute for Food Security, and my role through GIFTS. So I think we were sort of positioned uniquely to engage as a consortium member in that project. And I think that's due in large part to some of the unique structures that GIFTS has put in place. So I'd like to just present some of those briefly today before we continue with the discussion. So the Global Institute for Food Security, or GIFTS, is an industry, government, and academic partnership. It was founded by Nutrien, the province of Saskatchewan, and the University of Saskatchewan. And GIFT's vision is a world where everyone has access to safe and nutritious food, which I think is, a great vision. I think it's something that everyone can agree with and really connect with. And we're trying to achieve this vision through our mission, where we work with partners to discover, develop, and deliver innovative solutions for the production of globally sustainable food. And I do want to highlight the discover, develop, and deliver portion of the mission, because it does speak to kind of the range of activities that GIFTS is engaged in, from basic discovery-based research through to technology development, and then trying to deliver that technology to the marketplace through commercialization. And that last piece, that delivery piece, we completely understand and appreciate that work requires partners to do. So At GIFs, we work with partners. We try to fill the gap between the knowledge ecosystem that the universities have and the business ecosystem in industry. And this gap, I think, is particularly important in the ag tech space, just because that the product development cycles are often rate limited by the growing seasons, and so we have this natural longer term product cycle that's needed, and so GIFs hopes to fill and works hard to fill this gap. GIFs has also worked to set up some structures that will help engage with industry smoother and more quickly. And so GIFs launched the GIFs AgTech Enterprise, or GATE, very recently as a separate not-for-profit entity. And this really helps to provides a business window to GIFs, but really helps GIFs to engage with company partners to be more quick turnaround in terms of fee-for-service contracts and being able to respond to our customers and our partners' needs in a quicker manner. GIF's IP strategy, I think, is quite similar to strategies of many companies. The goal is to optimize the positive impacts of IP on revenue, reputation, and competitiveness for the institute. And we know that IP is critical to our success and the success of our partners, and really will help us to realize our vision and mission. Our approach to licensing is also quite straightforward. I think we try to make it simple so that we can have clarity with our partners at the outset, and definitely having those conversations early in the discussion of new partnerships and new proposals is important. And Dan and Jeff really highlighted that as well. So at GIFs, the first step of our approach is to define the field, and this defines the scope of where the partnership will be defined. Second, the partner company has exclusive rights to product IP in the field. So we want to do everything we can to make our partners and enable them for success. So we provide exclusive rights for that IP that's critical for their products. And then the third step is that GIFs retains the process IP. So processes, methods, tools, technologies, resources that are developed by GIFs to support the project. And that really allows GIFs to work with multiple partners, at the same time, and ensures that we can keep those processes in place within GIFs, and so when we enter into new partnerships, that there's sort of clarity from the intellectual property that we're bringing to new projects. I wanted to highlight a couple areas that are strategic directions for GIFs. So these vertical areas are the areas of focus in accelerated breeding, biomanufacturing, and policy and regulation. And then these horizontal technology platforms are the capabilities that GIFs has and offers as a fee-for-service or as a subcontractor model. And so these are services that could be very relevant to many of the PIC projects in that more subcontractor style arrangement. And so the Opal platform really houses the genomics and phenomics activities and associating those within GIFs. So these are important data sets and processes for plant breeding, for example. And Opal also houses a large range of state-of-the-art genome sequencing capabilities. So those capabilities are offered as a fee-for-service to many companies and partners. In data management and analytics platform, we have capacity to develop software, develop new types of data analysis, like artificial intelligence approaches or machine learning approaches. And then we have other technology platforms that target specific areas of plant science, so cell biology, plant growth facilities, engineering biology. So these platforms all provide the equipment and infrastructure to push forward new types of plant-based or plant-based food products. And we have great teams that are underlying all of these technology platforms. And then I just wanted to end by highlighting that we have a great business and innovation team, and these are the really excellent individuals that you would interact with as a partner coming to GIFs. And I just wanted to really thank this team. They've been working hard to establish new processes and structures to speed up the process, to help us move at the speed of business, which is one of the continual, I think, challenges that companies face when dealing with universities, is that if the time scales don't match, it's very hard to move forward. And so the team at GIFS has been working hard to solve that challenge. We are currently recruiting a director for business and innovation, but at the time, as an interim, Steve Webb, the CEO, has stepped into that role and really helped to align the team here to what we feel are the most important business needs in ag tech in Canada. So I'll leave it there, and happy look forward to the discussion. Thanks very much.
Well, thank you, Ian and Dan and Jeff. I think we have a few minutes left for questions, if any, and you can put them into the Q&A box as they occur to you. While we're waiting for that, I'll take an opportunity to ask some questions that were on my mind. Ian, you mentioned that you were involved with a PIC project before, and since this is on the minds of many of our attendees, I expect, as they're contemplating new projects, I wonder if you can speak to the importance of picking good partners for a PIC project, not necessarily involving universities, but just in general, the collaborative model, and how do you go about getting that chemistry right, finding the people that fit the technology slots that you've got as well?
Yeah, that's a great question. I do think that communication is really key, and especially in early on discussions to make sure there's like a good fit, and by good fit, typically we would mean the competencies, the capabilities, and the capacity are sort of matching. So all those three components have to be there. So if you're engaging with a partner or a university, and maybe the professor, their actual competency is in an area, and you're wanting them to do something that's slightly adjacent to that, sometimes that can work out, but often that can be kind of a recipe for a challenge. So that's one of the reasons why GIFS is trying to be very explicit with our competencies, so that it's clear, these are the services that we can offer. These are, where we have, competency and capacity to actually engage with new partners. So I think those discussions are important, and making sure that the fit is good early on in the discussions about new proposals.
Thanks very much. And to, I guess I'll address this one to Dan. Just based on your long experience with these kinds of projects, what's the biggest thing, I guess, that you see people getting wrong from a legal perspective, or from an IP planning perspective, getting into collaborative projects?
In a collaborative project, there's a couple things, but one of them is rushing too quickly to file a quick and dirty US provisional so they could make a presentation to some sort of a meeting. And quite often, in order for a US provisional to have any value, it has to have an enabling description of one of those 9 sources of revenue streams that we described that you're going to generate revenue with. So I think you need to think through a little bit more what the commercial value of that invention is before you rush out and file a US provisional. Something else that I think can be a problem when you have a few collaborators. Everybody wants to be an inventor, but it's not like publishing a paper where everybody that was involved in the project is listed as a co-author. There's pretty strict rules, as Jeff set out, regarding who is an inventor and who is not an inventor. And I had recently a client that insisted he was an inventor because he paid for the project, and that's just not on. The problem is that if somebody is listed as an inventor on a Canadian patent that actually did not contribute anything to the claims, that patent can be invalidated. And on the other hand, if somebody leaves the company and people are upset with them and they left under a cloud, but they actually did contribute to the invention, if they're not listed as a co-inventor, that's also grounds for invalidating the patent. So those are probably the 2 things that I think that stick out in my mind is rushing to file a US provisional patent too quickly to make public disclosures. And the second thing is spending too much time arguing over who's a co-inventor and who's not.
And maybe Jennifer, I know it wasn't directed to me, but I'll jump in and give my 2 cents on some things I see arise. And this kind of goes to knowing who your collaborators are and who's going to be involved in the projects. I don't think oftentimes enough investigation is done early on who's going to be involved in the project and what prior agreements or prior obligations they may have already entered into. I don't know how many times a situation has crossed my desk where a company thinks that they own all of the IP, only to find out that one of the team members they had working on it had previously executed a document that said things that they work on are actually owned by someone else, or something like that. So you really need to know who's involved, what are their prior obligations, are they free to actually assign the IP over to the company. So that would be something that I see that crosses my desk quite often. It's just not giving enough thought early on as to IP ownership and any background obligations that might be there.
So I'll just jump in and say this is an excellent example of the teamwork that Jeff and I do together. He's a lawyer and a patent agent, and so he brought that forward. I come from the business world and I have an entrepreneurial view on patent protection. So
I've got another question where maybe you can collaborate on this, Dan and Jeff. No one really wants to think about disputes, but do you have advice for companies wishing to do collaborative work about how to avoid or handle disputes that may arise?
Jeff, why don't you lead off?
Sure. I mean, obviously avoiding is going to a lot of the things we talked about in this presentation. I mean, clear communication at the outset, thinking in advance about what the deliverables are going to be from a project, what IP might be generated, who's going to need access to the IP to achieve their business objectives, and then papering it in clear language in agreements. And then tracking, from an ownership perspective, again, tracking it through assignments and everything like that. When it comes to enforcement, I mean, obviously a lot of these agreements will have, enforcement clauses, jurisdiction, maybe there's going to be a mediation mechanism engaged, but, generally, obviously, although I'd like to help everyone I can, I prefer it if, companies are able to discuss and settle it on their own. I think now sometimes discussing with the other side isn't the proper first step. Sometimes it is engaging a lawyer just to make sure that the course you're going to take is the right one. But when it comes to enforcement, I think, if issues start to arise during the project, again, I think communication is important. Can the draft amendments to the agreements be put in place? If someone is clearly in breach, that's where perhaps it's a situation where you should engage a lawyer right away before you engage the other side, just to make sure you don't do anything that jeopardizes your rights.
So I'll add to that. One of the slides that I was speaking to listed out some of the good management practices that the consortium members should undertake to list out what IP are they bringing to the table, how is that IP going to be used, and should have something in that agreement. If foreground IP does arise, there will be a process by which ownership and inventorship will be agreed to at a later date. And there should also be some termination clauses that outline, in the case that a dispute happens, how are you going to resolve the dispute and separate the consortium. So I like to say that the purpose of signing an agreement is not to start a project. What an agreement should clearly specify is, how do you end a project and exit?
Well, Ian, I wasn't going to ask you, but since you've lived this, What is your view on avoiding disputes? Are there things about the sort of the cluster model or the PIC collaborative model that help avoid disputes? What was your experience?
Yeah, so I mean, our experience on the consortium project was, we entered into the master project agreement with the consortium, and then since we were working very closely with Precision AI, our main role was to develop with them new artificial intelligence models and technology. We had a separate collaborative research agreement between GIFs and Precision AI that laid out more of the details around how foreground IP would be handled, and importantly as well, the data sharing components as well, how to manage data sharing, which is for many technology projects a very important thing to discuss early on as well, and to put in place structures to make it easy to share data within the consortium in order to achieve and push forward the objectives of the project. But at the same time, respect each member's sort of requirements in terms of protecting data that they're generating. And I think we were able to strike that balance well with Precision AI, but absolutely, I think the communication piece is very, very critical.
Speaking of access to data and access to other kinds of materials, I know that it's common in the software world to also be dealing occasionally with open source materials and open source data sets. I wonder if you have any experience on that, and any pitfalls or advice that you think our members should be aware of.
Yeah, great. Thanks for that question, Jennifer. So yeah, absolutely. The field of computer science, open source software and open data is a fundamental component, and really has contributed to the acceleration of the field over the past 20 years. And in particular in Canada, we have a unique strength in artificial intelligence research, for example, with some very, absolute leading groups. And all of that activity really is fundamentally based on this open model. Of course, working with companies, there's special consideration around confidentiality that needs to be respected. And so again, that communication early is important. When we go, typically as a researcher, when we do open source a piece of software, usually it's quite narrow and limited. So it would be a specific algorithm or a specific piece of software associated with a paper. And those can be very impactful because it helps people to use and increases our reputation and our impact. So it can be very important. But typically, all of the things that surround that to make it into a product, or there's a tremendous amount of work that is needed to do that, to turn a software algorithm into a product. And typically, all of those things, the product-based software would not be open sourced if we were engaging with a partner. So I think there's ways to do it. I also should mention that the typical model, the open source model that we promote, are permissive open source licenses. So things like the MIT license that permit commercial use and really give our partners freedom to operate with any of those specific pieces of software that are open source. Open data is also even a bit more challenging when working with partners, because certainly they want to protect those assets. We do utilize public data sets in these partnerships as a way to do, say, a proof of concept on a public data set that then could inform the company's analysis of their own data. So certainly we use public data sets oftentimes when we're working with partners.
Thank you. That's very useful. Jeff, I have just one closing question for you that was triggered by your slide about all the different revenue streams / claim types. And the question that I get asked quite often is about patenting of recipes, and whether recipes are necessarily kept as trade secrets.
Yeah, it's a tricky question. So compositions of matter, which, often now I guess recipes, do you mean the actual components of the end product, or do you mean the recipe, the process of making it, I guess?
Well, both of those things, I
Okay,
guess.
both those things. So composition of matter containing, various different components, they are patentable. It's patentable subject matter. It can be a very tricky space to patent in. And I have done a lot of patenting in that space, whether it be working with vaccine companies or cannabis companies or whatever have you. It's a tricky space to patent in because often the ingredients of the product are known ingredients. So, US examiners can be, I find, particularly difficult in getting claims to new combinations of known ingredients, just in how they combine prior art references. So it is patentable subject matter. It can be very tricky. Sometimes your claims can end up being more limited than you'd like because you need to rely on, weight percentages or something to that effect. The recipe for making something, also patentable subject matter, but perhaps something you want to consider keeping as a trade secret, because oftentimes the recipe is not going to be disclosed to the public. It will be contained within closed doors of the business. So often there's a business decision there to be made on whether or not you should disclose the process for making something. If you think you can, if it's a difficult enough process that you think you can keep confidential and others won't arrive at easily, then there's probably merit to keeping it a trade secret. If you believe once the product's released, the process can be easily reverse engineered, then there's merit towards going after the patent application.
Thank you. And boy, I could do this all afternoon with taking advantage of the brain trust that we've got here today. But what I think I will do is make your contact information available to the attendees today. And before we wrap up, just want to thank our speakers for their excellent presentations and insights today. It's a privilege to have you with us and to have your expertise in our ecosystem. The speakers' presentations and that Gowling's summary of university IP ownership policies will be made available to attendees after the session. I also wanted to just do a very quick little plug for ongoing and future project opportunities at PIC. Although our first Fund 2 project call has just closed, there's a good chance of another one opening in the not too distant future. And there's also, I should add, an open call for expressions of interest in our AI stream. We'll make links available to the program guides for both streams and would be happy to connect you with members of our project development team if you have any questions. If you have IP related questions, I'm happy to be a resource or to connect you with other fine resources like the people that you've heard from today. And I'll make sure you have my contact information as well. Finally, just thank you in the audience for your attendance today, and please stay tuned for future webinars promoted through our newsletter and our LinkedIn channels. And just have a great day. Thanks all.
Thank you.
Thank you, Jennifer.